Good morning, everyone, and welcome to this week's Purdue at Westgate webinar series. My name is Samantha Nelson, and I'm the program manager here for the Purdue Foundry at Westgate, which is located within the Westgate Academy. We at Purdue at Westgate strive to promote business and talent growth, and we want to help support you as a startup, small business, and academia. We strive to be that regional hub of connection and support. Purdue at Westgate is located within the Westgate Academy, and the Westgate Academy is a technology incubator, training, office, and conference center. We are located within the Westgate at Crane Technology Park, which is directly outside the gates of the Naval Support Activity Center in Crane, Indiana. We would like to thank our sponsor for this webinar, CACI International. CACI International is an American multinational professional services and informational technology company headquartered in Arlington, Virginia. They provide services to many branches of the U.S. federal healthcare. We're excited to have a satellite office of CACI within the Westgate at Crane Technology Park, supporting the Naval Weapons Support Center in Crane. Today, we are excited to be hosting a webinar with Tyler Drost. Tyler is an attorney at Goodwin Law who focuses primarily in intellectual property and business law. I have had the pleasure of getting to know Tyler within the last few years. As you will hear, he is extremely knowledgeable within these areas of law. Goodwin Law has a main office in West Lafayette, Indiana, but in the next couple of weeks, Tyler has informed me that they will be opening an office within the Evansville, Indiana area. Happy to hear of their growth. We ask that you mute your microphones, and if comfortable, you may leave your videos on during the presentation. Please feel free to use the chat function at the bottom of your screen to ask questions, and Tyler will answer these questions at the end of the presentation. Following this webinar, a copy of the presentation Tyler is presenting, as well as a copy of the recording, will be sent to everyone. Saying that, I would like to introduce you to Tyler Drost.
Hello, everyone. Hope everyone's having a great day. Thanks for joining us today for this presentation. Hopefully, you guys find it interesting and not too dull of a topic. It's something I deal with on a daily basis, and so something I could talk about forever or ad nauseum. And I'm hoping that this will provide a little bit of insight for you all. It's going to revolve primarily around intellectual property law. Let me pull up and I'm going to share my screen here and get the presentation loaded up. And so I'm hoping everyone can see the presentation now. Thumbs up or a nod would be great.
Yes, awesome. we can see it.
Awesome. So yeah, today I'm going to talk a little bit startup law kind of 101. We kind of have a little bit of a and this one's going to focus primarily on intellectual property law. So just a little bit of agenda of what we're going to discuss today. I'm going to give a little bit of brief background about myself and Goodwin Law. We're going to do an IP overview, so intellectual property overview, discuss the various areas of intellectual property law. And then we're also going to touch briefly on some different documents that early stage companies and even established companies will want to focus on having in place as it pertains to intellectual property. And then at the end, I'll take any questions you all may have. So what we believe at Goodwin Law kind of sets us apart is we kind of have a slogan that's called legal strategies with a business perspective. And so a lot of the attorneys at our firm have either been in business in different industries, have their own businesses in different industries, and we really feel like our personal experiences in the business environment really helps us provide a better legal perspective, legal strategy for our clients. And we really think this makes a difference when we're providing and counseling our clients. So as Samantha mentioned, our main office is located in Lafayette. We also have an office in Indianapolis, Indiana, right downtown. We have an attorney up in Minneapolis who works remote up there, one in Wisconsin. And then we're getting ready to open our office down in Evansville, Indiana, which is where I will be based out of. I had previously worked in our Indianapolis office for 5 years and originally from Evansville and had the opportunity to kind of move back home and really trying to grow our practice down here. And so Good Wine Law practices primarily as a business boutique firm. I would say our focus is in business law and anything tangentially related to business law. So whether it be real estate, intellectual property, mergers and acquisitions, we kind of hit the game on that. It's easier to say what we don't do. We don't do criminal law, don't do personal injury, medical malpractice law, and don't do any family law. So diving into kind of the intellectual property aspects of everything, we're going to do a quick overview. And so some quick questions to kind of consider. What type of intellectual property is applicable to my company? These are things that, this is a question you should be asking yourself when you're a startup, or even if you've been in business for a while, because maybe it's not something you considered when you're initially starting. Who or how is my IP being generated? So who is actually generating it? Is someone, an employee in my company generating it, or am I hiring it out to someone else to kind of generate potential intellectual property assets for my company? Should I invest in protecting it? So this is a cost benefit analysis. Maybe it's not something worth protecting, or maybe it's not protectable. And then what else am I not thinking about? So these are some of the questions we're going to answer today. Against intellectual property law. So intellectual property, what is it? It's kind of a broad definition, right? So it's tangible and intangible assets that originate from creative mental activity is kind of the definition we place on it. And so it can span a wide range of things. It can be difficult to define, it can be difficult to identify, but it's something that we encourage our clients to sit down and kind of do an exercise on and saying, hey, what is an asset that is potentially protectable, that is crucial to our company? And so how do intellectual property assets, how are they protected? They are protected through a variety of different types of intellectual property protection. So we have patents, trademarks, trade secrets, copyrights. They can be protected via agreements. It could be something as simple as a client list. People don't think about this, but a lot of companies work really hard to establish and maintain client contacts and create that client list. That is an IP asset that you want to potentially invest in protecting. And so these are a lot of reasons formal entities are formed. Especially around patents, you'll see two inventors coming together, whether it be at a university or outside of a university, and say, hey, I have an idea, I want to get a patent on it. One of the first things we strongly encourage, especially around patents, is forming an entity for that entity to hold that asset. And we'll kind of talk a little bit of why patents are a little bit different from some of these other ones when it comes to that, but it is a huge trigger in potentially forming an entity. So brief definitions on different types of intellectual property. So we have design and utility patents. And so what a patent does, it protects your idea. We'll get into a little bit more detail, but the design patent protects the ornamental characteristics of your idea. So a physical embodiment, whereas a utility patent protects, for the most part, how an item may function, an idea may function. A utility patent is what you're probably most commonly thinking of when you hear the term patent. Trade secrets, so this protects information. Trademarks, they protect source identifiers. So this is when you're building a brand, you want to ensure that people know when they're buying a product with your trademark on it, that they're getting the quality of product that they're accustomed to receiving from your company. Copyrights, so protecting expression. So typically artistic expression, and it has to be affixed to a tangible medium. And then agreements, so protecting relationships. This is what I mentioned earlier when it comes to client lists and things like that. You can't just take your client list and start their own company with your client list and reach out and start soliciting all your clients. So just a brief, really initial definition for each one of these. We're going to dive into them kind of one by one here. So the first one we're going to talk about is copyrights. So copyrights are probably something that everyone's fairly familiar with. A copyright protects the tangible expression of original work when created. So this is typically some kind of artistic expression And the key here is that it's an original work. So if you copy something, obviously it's not original and you wouldn't be able to get copyright protection on it, but if it's original, you would. So this is, for the most part, the only form of IP that is immediate to some extent. We'll talk a little bit about trademarks here in a little bit, but as soon as you create an artistic expression and you affix it to some kind of tangible medium, whether it be a paper now, you've created a copyrighted work. So it is entitled to copyright protection from that data creation. No official registration is needed, even though the US does have a copyright office where you can get a federally registered copyright. So common law rights do exist. However, if you were wanting to ever file litigation or infringement actions against someone, it's almost essentially a requirement now that you get that copyright registered. And so you'll see this almost on every web page you go to these days. This copyright denotation down at the bottom of it, you'll see it at the end of our presentation. It's the circle C, the name of the creator, whether it be your company or yourself, and a date that is created. Usually it's just going to be a year, 2020, 2021. You may see a range of dates if the work has been modified or created over a range of time. So 2016 to 2021. Of getting a federally registered copyright is that your damages are greatly increased against a potential infringer. So it's another pro. And for the most part, getting a copyright registered is not a hugely costly, a huge cost burden, and is very beneficial in the long run. And it's something that most people can probably do on their own. They don't have to necessarily enlist an attorney like me to do it for them. There's a lot of tutorials the Copyright Office has to kind of show you how to do that. And so if you're looking at potentially making some cost savings, this is an area where a lot of people can help themselves. So key actions, so use proper marking on all your published or documents, copyrightable documents. So manuals, promotional materials, publications, your website. The reason to do this is, again, it's for the most part free. It helps protect you against outright copy. Living in a digital age, you don't see this as much. I guess the corollary would be sending an email to yourself, but back in the day, people would email a post-stamped envelope to themselves to show that, hey, this was the date that I actually created this, right? And this was my proof, because it's a sealed envelope that's postmarked, and so that establishes my date of creation. And so, again, this is a good option for a lot of people. A lot of, and it's really incredibly important too, and it's a consideration for a lot of people when it comes to building their website and using photos on websites, and something that they need to be aware of, that they can't just go to Google and pull off an image off Google Images and put that on their website, because there's a very good chance that that is a copyrighted image. Someone owns that, and unless you have a license to use that, you're potentially infringing their copyright, right? So common things that are copyrighted, so original works of authorship, the standards are, what most people would think of: poetry and novels, movies, plays, performances, songs, computer software, and then architectural design is kind of like a niche area, but is copyrightable as well. So as I was mentioning, images are probably one of the largest copywriting components that most people need to be worried about. Even if your business is not really generating their own copyrights, you need to be aware that, hey, you just can't pull images off websites and use them on your website, because there could be a risk of infringement at that point. And we've had clients come to us with cease and desist letters, demand letters saying, hey, you used an image that isn't yours and you don't have a license to it, so now you need to pay us. And so something definitely to be aware of, especially for early companies, businesses that may not be enlisting a marketing company that may be generating original content for you. So things that copyrights do not protect are facts, ideas, systems, methods of operation. It could protect the way these things are expressed. Another thing that a lot of people would ask is, hey, I want to get my title copyrighted to something. You can't really copyright short phrases. And so it's really, your traditional kind of, hey, I have a book or I have images or I have, movies or music that I want to copyright. Software, for a period of time, it was being copyrighted. Obviously, if you have some kind of unique algorithm implemented in your software, you probably don't want to copyright that because you don't want it to be public record. You could redact software code, but at the rate software code is kind of being turned over, you don't see it as much. Plus, there's a lot of open source software now. So jumping to trade secrets. So this is another area of IP where there is potential cost savings in something you can do on your own, because it is something that you don't technically have to take an affirmative action to protect, but you do have to exert some kind of control over the information. So a trade secret is information that has economic benefit from not being generally known. And so what most people would probably think of is secret recipes, right? Those are my trade secrets. So KFC spices recipe, the Coca-Cola recipe. The thing that you do have to do is make some kind of effort to maintain the secrecy of the actual trade secret. So you can't just be obviously posting your trade secret out to the public for everyone to see. And quite frankly, you really don't want it to be extent that they don't need to access it, right? So the key is secrecy creates value worthy of protection. And so maintaining the secret at all costs possible is the important part, in placing safeguards to maintain that secrecy is critical. So, if you have a trade secret that you have on a network that is freely accessible to everyone in the company, even though everyone in the company doesn't really need access to it, that potentially puts at risk the ability to claim a trade secret to that anymore, because you're not really maintaining a proper safeguard. One thing to definitely keep in mind, especially in early negotiations with other companies, potentially investors, and or maybe you're having a subcontractor do work that may need access to the trade secret, is having an NDA in play, so a non-disclosure agreement. These are very useful and important documents to have. So a standard non-disclosure agreement is incredibly important and helpful. But to the same extent, you don't want to disclose your trade secret unless it's absolutely necessary. And so if you are disclosing it, having that NDA and confidentiality agreement will be critical. But really, you want to limit that access as much as possible. So as I mentioned, it must be kept using proper safeguards. It does not. So one thing that is a differentiation, and a lot of times you'll see a company, and we have companies come to us, and they may have an idea that may not be easily, a trade secret is most beneficial when it's not easily ascertainable from re-engineering or reverse engineering, right? Something that can't be really reverse engineered, because or try to maintain it as a trade secret. And the kind of costs and trade-offs there are, is if it's not easily to be reverse engineered, maybe it makes more sense to maintain that as a trade secret. But the downfall there is it doesn't protect you from independent development. So if someone else was able to come up with your same recipe or same algorithm, you can't really, as long as they didn't misappropriate it or steal it from you, you can't really stop them from using it at that point. Whereas a patent, if you had a patent on that, could potentially enforce a patent against them. But again, a patent is limited in term. So trade secrets could last forever, but at the same time, you run the risk of someone independently developing it. And so it's a trade-off, is what's the risk reward there? Can I maintain this trade secret? Is it easily ascertainable or able to be reverse engineered? If so, then maybe it makes more sense. The other benefit there is, to some extent, trade secrets can be lower in cost. So you're not paying for patent costs, patent drafting services, and patent prosecution fees. You would have costs, obviously, with maintaining the secrecy there to some extent, but those are and can be a lot lower. So as I mentioned, these are used when we cannot detect infringers. So a lot of times you may see a method, which there are method patents, but again, it's going to be hard to detect if someone's infringing your method unless that method is the only way to create your product, right? Because a lot of times people are creating things behind closed doors. And so unless you have access behind those closed doors, you're never going to really be able to know if they're using your method. And the other is when others cannot detect how we're doing it. So as I mentioned, some of the examples below, the Coca-Cola recipe, Kentucky Fried Chicken, spices recipe. That next picture is kind of metallurgy. This is spring cycles, specific temperatures that something is maintained at for a specific period of time. And those heating and cooling cycles can't really be easily ascertained without someone teaching you them or having you or providing those instructions to you, right? So that is a classic example of where a trade secret makes more sense because it's almost impossible to reverse engineer that. And then a black box, so like an algorithm. If you have a specific algorithm that one can't really deduce, that may be something to keep as a trade secret as well, instead of including that in a patent or, as I mentioned earlier, filing as a copyright. So again, what is typically protectable as a trade secret, or what are the most common types of things that are protected as trade secrets? So method, techniques, or processes. So as I mentioned, metallurgy, specific order of steps, particular environments, means of completing a certain step or a process. Formulas, recipes, tooling. So a lot of manufacturing tooling is specifically created and designed in a manner that may not be easily ascertainable as to how that tooling is used and or implemented to create the downstream invention. So compilations, customer lists, supplier lists that I mentioned earlier, these could be maintained as trade secrets to some extent. Programs, devices, and just general business info. So how a business plan may be carried out, market surveys, marketing plans, R&D, things like that. So a lot of things that a company probably has in their possession that they don't maybe initially realize has and large value for the company. And so again, before I guess turning to patents, things to keep in mind is NDAs and employment agreements and confidentiality agreements within those employment agreements. If anyone's going to be having access to those documents is a really good way to help safeguard that information. So next, we're going to talk a little bit about patents. This is an area of intellectual property law, which oftentimes is kind of called, there's hard IP and soft IP is what you may hear. Patents are what are considered the hard IP, and this is what a lot of people think of when they hear intellectual property. So what is an actual patent? So a freely revocable government monopoly for only a limited period of time, right? And so if you are able to get a patent on something, you are able to prevent other people from using your patent or creating your invention or using your invention. So it's a grant by the government to the inventor of the right to exclude others from making, using, selling, offering for sale, or importing in the US, the invention for a limited period of time, right? And so that enumerated list of making, using, selling, offering for sale, and importing is critical to know. It's not just preventing them from using it, but also potentially importing it. So, a lot of people, and patents can be filed right in the US and internationally. And so each country has their kind of own patent regime. And a lot of clients may come to us and say, hey, where do I need to file a patent? And most often it's going to be where you're selling it. It's going to be the most important place where you're going to want to file your patent. But it also, the next consideration is, hey, where are you actually making it too? And so since a lot of items are made overseas, it may be beneficial to file for patent protection in those areas as well as if you're going to be selling it in those other jurisdictions too. But kind of the key piece that most people don't think about is the importing in the US. And so if you have a patent in the US and someone is making your invention somewhere else, but you don't have a patent necessarily in that other jurisdiction, but they're shipping it back into the US, you're able to prevent them from importing that into the US if you have a patent. And so, as I mentioned, the patents are for a limited period of time. And there's kind of two different patents that I'll go into. There's, as I mentioned, the design and utility. And so the utility patent is 20 years from the date of your non-provisional application. And a design patent is for 15 years from the date of the grant of that actual patent. So it's a little bit different triggers, right? One's from the date of filing, the other is from the date of grant. And as I mentioned, most developed countries have their own patent system, and we have different treaties that we participate into that can help alleviate some of the headaches in filing in different jurisdictions, and also provide priority to any patents that you may file here in the US. So when we're talking about patents and when I'm discussing patents with clients, the way I kind of outline a patent to them is, and what we should be considering early on in the process is there's kind of 3 hurdles to overcome when the patent gets examined by the USPTO. And it's usefulness, novelty, and non-obviousness. So section 101 pertains to usefulness. And it's pretty much what it sounds like. Is this something useful? And almost always that is going to be yes. So almost always you're going to get over that usefulness hurdle. More recently, 101's been used as a subject matter eligibility disqualifier and was really cracked down about 5 years ago upon a ruling that really cracked down on software applications. This ruling's kind of been, I don't want to say walked back, but the strictness of it has kind of been walked back to some extent, where software patents were really having a hard time getting granted. And now it seems like they're opening up that possibility a little bit more. The next hurdle is kind of new or novel. Is your invention new or novel? Is there something that exists out there that's exactly like it, basically? So is it not previously known or used by the public, placed on sale, described in a printed publication, or invented by another? And when we're talking about novelty, we're talking about a one-for-one kind of comparison. Business 103. So is there a long felt need for this? Is there failure of others to create this invention? Was there unexpected result? Is there commercial success? These are things that the USPTO considers when they're trying to make a non-obviousness. And what's the difference between novel and non-obvious is there doesn't have to be one-for-one comparison. There is usually, what happens is the USPTO is going to utilize more than one piece of prior art, so previous patents, and say, well, inventions A, your invention A, inventions B include elements 1 and 2, and invention 3 or invention C includes elements 3, and your invention includes all 3 of those, and it would have been obvious to combine those, right? And so this non-obviousness rejection is kind of the most difficult to overcome and is most often cited by the USPTO. And so novelty 102. So the invention cannot be known or used by the public before the invention. It cannot be sold or offered for sale more than 1 year before the application is filed. And so this caveat is fairly unique to the US. Almost everywhere else in the world, if you publish or sell or make accessible to the public your invention prior to filing for patent protection, you could be precluded from obtaining patent protection. So this is an important thing to consider if you're going to a trade show, if you're going to just a conference and you're going to be disclosing your invention, and it's going to be publicly accessible, that you may want to consider getting something filed with the patent office sooner rather than later. Otherwise, and this is especially true if you're thinking that you may want to file outside the US. So the US grants you this 1-year grace period after the public disclosure to file for protection, whereas most countries do not. And so if you do have any intent on filing outside the US, you really want to get something filed preliminarily before making such disclosures. And so this is for products, offering to sell them and or just a general public disclosure. In the US, we kind of have a patent process where there's something called a provisional application. Provisional applications aren't really examined by the USPTO. They're more or less, I call them rubber stamp applications, where if you meet all the filing requirements, they rubber stamp it, give you what's called a priority date. And then you have 1 year from that priority date to decide whether or not you want to file what's called the non-provisional regular application, or potentially a PCT/international application for your invention. And so the nice thing about provisional applications is that the filing fees are relatively cheap and affordable. The formality requirements of them are very low. And so you can use hand-drawn drawings, you can use pictures, you can use a lot of different things. And this can help you establish that initial priority date, and also protect you if you think you're going to be going to a trade show and you're going to be disclosing it, and you want to have that initial protection, preliminary protection or precautionary priority date. So actions that can destroy novelty, preventing valid patent rights. So commercialization and marketing activities, disclosure outside the company without an agreement, and field tests under certain circumstances. So then, as I was mentioning about non-obviousness, so it cannot be obvious at the time of invention to one of ordinary skill in the art. And what the USPTO does at the time of examination, your patent to other patent applications, other publications, to seeing if they disclose aspects of your claims. So prior art, and this is what we call prior art, right? So prior art disclosures are what are publicly available and that predates your priority date, the date of filing your invention. And so if they predate your priority date, they could potentially be used as prior art against you. And this is kind of getting in the weeds. There's of patent law and patent examination. There's the Graham versus John Deere analysis that's kind of used for this non-obviousness analysis that the USPTO uses when examining patents. So it's the extent of the scope of the prior art, the differences between the invention and the prior art, and the ordinary skill. And so, as I mentioned earlier, as an example, you say your invention includes elements 1, 2, and 3. Well, there's a novelty aspect because there's nothing exactly like it, but maybe there's invention A that includes element 1 and invention B that includes elements 2 and 3. And what you will see from the USPTO is, hey, you can combine these two inventions together, and it includes all the elements of your invention, and it would have been ordinary. It'd be obvious to one of ordinary skill in the art to do so. And so a lot hinges on, well, would it have actually been obvious to combine these two things? And so it's digging into seeing, hey, has there been commercial success of this new invention that wasn't normally seen prior to then? Was there a long felt unmet need that this invention is accomplishing? Obviously, failures of others to have tried in the past is some kind of indication that it may not have been obvious. And then a really critical one is if there's an unexpected result. So one of the things that we look for is, hey, does the patent that they actually cite against us way that we are implementing it in our invention? And if that's the case, then obviously it would not have been obvious because they're actually teaching away from doing it the way that we are doing it. And so these are considerations to make when determining whether or not maybe it makes sense to file for a patent. Because a lot of times you'll say, well, no one has a patent, a product exactly like mine. Well, it's like, well, the analysis then is, well, is there someone out there that has similar products that you could easily combine. And if you combine those two things, is it provide the product that you're wanting to provide? And if so, it could be difficult to overcome that burden. Maybe it doesn't make sense to try to get protection on it because you may face this obviousness rejection. So I'll run kind of through the patent process real quick here. It's a long, cumbersome process. So I mentioned earlier, kind of generally, there's a provisional application. And so depending on what route you go, you don't have to file a provisional application. You can immediately file a non-provisional application. But if you do file that provisional application, that's kind of a 1-year preliminary period that you would add on to any of these dates I'm going to kind of get ready to go through. So our typical process is we will meet with an inventor after they develop a new idea. We have an invention disclosure form that we use that helps us collect the information both about the inventor themselves that we need for filing the application, as well as their invention. And so it kind of asks the questions we need answers to when it comes to drafting the actual patent application. And it's something that, you know, if you're an early startup company, that you really need to sit down and contemplate is, hey, are we generating anything that we may want to pursue patent protection on, and what kind of value will that return? And make multiple reasons to potentially pursue patent protection. One is not just to have a monopoly on the invention itself, but another is potentially for defensive purposes. Maybe you don't intend on actually going out there enforcing your patents and suing people actively, but maybe having something in your IP portfolio to use as a defense purpose. If someone came after you, then maybe you have a patent against them, and maybe that could wash out any claims against you, or potentially present some kind of barrier from them coming after you. Additionally, it could be a good marketing tool, right? If you have and can say that you have a patent pending, it shows, one, that you're pursuing potentially protecting your idea. It provides some indication to investors that you've contemplated this, right? That maybe you do have an asset that is protectable and that you're taking proactive steps to protect it. Be absolutely critical that you get a patent. So it's really important to consider these things early on in the process, and really sit down and think, hey, is this something we want to pursue? And maybe it's not something that you have an intent in the long run of pursuing, but maybe in the initial upfront, maybe it's worth filing an initial provisional application early on in the process. And so that's kind of where we come in. We come in, and after we get the invention disclosure, we'll meet with our clients, and we'll help evaluate kind of, hey, is this actually a new and non-obvious idea? So it doesn't meet this legal criteria. Now, we can't make necessarily a legal determination off the bat, because that's the USPTO's job, but we can help identify these potential issues that could occur downstream, right? We can do patent searches, right? We can see what else is out there currently and say, hey, these are the patents that, help us try to identify how yours is different from what currently exists. And then maybe we can see if there is a potential patentable idea there. Is this idea valuable? So is this an asset going to be of great value? Is it of importance to the company? So patents are not cheap. They are expensive. Initial applications can be, between $10,000 to $15,000. And by the time you're all said and done, you could be spending upwards of $15,000 to $25,000, or even more, depending on what the invention is, and getting a patent. And that's just obtaining the patent, right? So if you're actually going to be out there enforcing the patent, that's going to cost additional funds. And so why are we getting the patent in the first place? And does the value that we're going to be putting into it have a benefit in the back end? Is it better kept as a trade secret? So we kind of already talked about this. Is this something that may make more sense as keeping as a trade secret? What is the potential likelihood of commercializing or licensing it? So this is one of the critical pieces that most people are considering and want to pursue a patent for, is they want to commercialize their idea, and maybe they need the patent to be able to actually go out there and license it. Is it close to the final iteration? I tell clients a lot of times you don't want to wait until your final iteration to file for patent protection. You want to at least get that provisional application filed at the point where you're able to adequately describe it to one of ordinary skill in the art how to create your invention or how to use your invention. And if you can do that, then that's the time we want to file the patent. Now, if there's potential tweaks and modifications that could happen in the interim of that 1 year provisional period, then we can go from there. But at least if we can get the rough idea down and you're able to articulate how it actually functions and works, then that's when we want to do it. We don't want to wait till you have like an MVP in place to file that patent protection. And I mentioned earlier, defensive purposes, we call this kind of a war chest, right? Maybe it makes sense to build up your war chest, even though you never want to have to use the items in your war chest. It actually could be used for defensive purposes rather than offensive purposes. So after we sit down and consult with you, get the invention disclosure, we'll draft a patent application. We'll usually have a little bit of a back and forth between us and the clients with drafting, making sure everything is appropriately described and characterized. And then we'll file it with the USPTO if we're just filing in the US, or if we're going to be potentially filing outside the US, you can file a PCT application, which is somewhat of an internet rights to all the countries, but it allows you to then file downstream applications in each country you want patent protection in. So it kind of is more of a holdover application, almost like a provisional application for the international sphere, where you then have additional time to decide which countries you may want to file in. So what happens at the PTO? So we've kind of talked about this. So as soon as we file it, the first thing that's going to happen is you're probably going to wait a long period of time. And typically it's going to be between 16 and 24 months before you hear anything from the USPTO after filing it. And once you do finally hear something from it, it's going to be most likely what's called an office action. And basically this is a rejection saying, hey, your invention is not patentable either for one of those reasons that I previously set forth, 101, 102, 103. And here's the prior art that is going to be used against you, and this is why it's not patentable. So after we'll go back to the client and we'll determine, hey, is what they're citing against us actually accurate? Does it make sense? Are they characterizing things correctly? Are they mischaracterizing different things? And then we can kind of form a strategy on how to pursue it going forward. So we can either file an argument against the rejection's merits. So, hey, you're completely mischaracterizing the piece of prior art that you cited against us, and that's not how it actually works. Or, hey, maybe we need to amend the claims a little bit to be a little bit clearer on how our invention actually works that will further distinguish it from the prior art. Or you could alternatively just abandon the application. Maybe they found something that's exactly like yours and there is no hope really for the application going forward. Obviously, that's something that could be caught doing a patent search on the front end. But again, patent searching is beneficial, but at some point it becomes kind of a futile effort because the provisional patents that I mentioned are accessible to everybody or anybody really, except the people that filed them. And so someone could theoretically have filed your exact invention a month before you, and a patent search would never return a result because that application isn't published. So to some extent, initial patent searching is beneficial, but spending too much time doing patent searching is really a futile effort, and it won't return every single result possible. After we file our response, the examiner may issue a new office action citing to different prior art, or they may state that the application is now in condition for allowance. And so this back and forth process can go on for quite a long time, really as long as you want it to. If you keep getting rejections, you can keep filing a request for continued examinations. You could eventually appeal if they keep filing an office action, or you could file what are called continuation applications. And so it's a very long process. Usually it's going to be between 2 and 3 years from the date of filing. your application before you would actually get a patent issued. And so this is what we call patent prosecution. This is not patent litigation, but it's actually the fight between us and the USPTO as to getting that patent actually allowed. And so there's traditionally a few parts of a patent application. So there's the abstract background, summary of the invention, drawings, brief descriptions, detailed description of the invention and claims. I won't hit too much on this. I'll show you some examples here in a second, and it kind of needs to be through because I'm running a little bit behind. But the most important part really of a patent application is your claims. And so this is what defines your patent scope. This is the four corners of the deed if you're referring it to it actually as a real property. And so the claims is what outlines what you're actually gets issued by the patent office. Whatever claims get issued is what you actually have protection on. So this is kind of a general, if you go and I encourage everybody, if they're interested, going to Google Patent, just go to Google Patents and type in a string search of anything really, and you can pull up a patent and you can see kind of how it's structured. But this is the kind of the front page. You see the abstract here, you see the inventor, applicant's information, the patent number, the date it was patented. And then these are what the claims kind of look like. So you see the invention and claim is a power lift gate apparatus for placement in a truck bed to move a tailgate. And then the apparatus comprising elements A, B, and C there. And so that is what the invention is for, and that is what the patent is for, and that's what you have protection on. And so if someone were to create an invention that only includes those first two elements, they wouldn't be infringing your patent. But if they included that third that include all three of your elements there plus one more, they would still potentially be infringing your patent. And so that's something to keep in mind too. If you're just adding something onto someone else's patent, you're maybe still infringing their patent. And so it's kind of a unique area where you may still have to get a license to someone else's patent to actually practice your patent. And so design patents, we'll talk about this real quick. It protects the appearance or the ornamentality of something. And so the protection on design patents are very, very narrow. And so it's easy to design around it because if you change the ornamentality or the design just briefly or barely, you can get around a design patent. So these were previously used for, I mean, the Coke bottle is a famous one, but bumpers in the automotive industry. So OEMs would be protected, right? So someone couldn't just create a new bumper and start selling them. Easier to obtain than utility application. But again, their scope is very narrow and the applications themselves are very brief. Primarily, they're just pictures. So here you'll kind of see to some extent what these look like. Usually you'll have, 6 to 7 figures that show all different angles of the actual design itself. And that's what your protection is on that specific design. So going to kind of the last thing, trademarks. So word, name, symbol, or design used to identify the source of goods. So this is what most people think of when they're talking about brands, right? And so you got famous brands like Nike, Adidas, Coca-Cola. All these names are trademarks and they use to identify the source of the goods or services that they provide. So Nike for shoes, apparel, things like that. So the issue here, and when you're building a brand, is you want to think about, obviously one of the first things a company thinks about is, hey, what is our company name going to be? And so trademarks are a critical consideration early on in the process of forming a company. You want to make sure that you're not infringing someone else's trademark. And the analysis isn't a one-for-one, hey, my name isn't exactly the same as your name, so I'm okay. It's would this present a likelihood of consumer confusion? And so using a K instead of a C in your name isn't going to really create a different consumer impression, right? So it's not a one-for-one analysis. It's hey, would a consumer be confused if they saw these two names next to each other? And so what goes into that is not only the similarity of the marks themselves, but also what your products are. And so you can have people that have the exact same name as you, but maybe they're in a completely different industry, and therefore there wouldn't be any consumer confusion, right? So someone who's looking for rocking chairs isn't going to be confused when they go to a different website and they're selling, heavy industrial machinery, right? Obviously, that's not the same company because they're not selling the same products. So a key action here is to ensure that, one, you're not infringing someone else's trademarks, but also that you're getting your mark registered potentially either in the state you're operating in, or if you're going to be operating nationwide in the US, or alternatively, if you're operating outside the US, in those other countries as well. There's kind of varying degrees of trademarks. I'll kind of run through these fairly quickly. So there's common law trademarks. And so it's kind of similar to copyrights. Common law trademarks are essentially established as soon as you start using the mark in commerce. And what I mean by using the mark in commerce, as soon as you start providing a good or service to the public, mark rights. These common law rights only extend to the geographic area you're operating in. And so if you only have a restaurant in Evansville, Indiana, then your trademarks really only extend to that geographic area and what's called the natural zone of expansion. In court, there's no presumption of ownership, so it's going to be on you to show that you are the actual trademark holder and owner. And when you see the markings TM or SM, these are the markings that signify common law trademark rights. So we strongly encourage our clients that if you want to try to claim ownership of a mark, that you start labeling that TM or SM, so trademark or service mark. You don't see the SM as much, but it's technically supposed to be used when you're providing a service and not a good. And that is providing some notation to the general public that you're claiming a trademark right to this. The next kind of level of protection are what are called SM. You register these in specific states, and this is really for people who are only operating in a single state. If you're operating in more than one state, we would recommend you filing a federally registered mark. And so federally registered marks are filed with the USPTO. They're reviewed and examined by the trademark office. It's a process kind of similar to patents. It's not an immediate thing. You file your trademark, it gets reviewed by a trademark examiner, and they look at their database to see if there's any potentially confusingly similar marks before they will issue a registration. These are marked with a circle R denotation. So that's the difference. When a mark actually becomes registered, you can use that circle R denotation. Provides protection throughout all of the US, lets you bring the trademark case in the federal court. And if you do have a federally registered mark, you show that maybe they have some other superior trademark right to you. So level of trademarks, I know we're kind of running out of time, but level of trademark protection. So you have generic marks that are never protectable by the federal government, right? And so what a generic mark is it is the word that the product is. So apple for apples would be generic, right? You also have to run in be careful of genericide. So marks that become so famous that they then become associated with the product. So Kleenex, yo-yo, thermos, people start substituting those words for the actual product. Descriptive marks is kind of the next level of strength when it comes to trademark protection, but these are really still not great marks, and they only are able to be federally registered if they acquire secondary meaning or distinctiveness in the industry. So American Airlines, they somewhat describe the product or service that you're providing. And so they're generally not going to be protected under a federal mark analysis unless they acquire secondary meaning. Suggestive marks, you're getting a little bit better here where it's requiring an extra step to make the connection between the product and the mark itself. So Coppertone for suntan lotion, Whirlpool for washers, right? And then the best and strongest types of mark are what are called fanciful or arbitrary marks. Fanciful marks are marks that are created specifically to market a product. So Kodak, Xerox, these are words that didn't originate or have existence in the ordinary vernacular until they're created by a marketing company. And then arbitrary marks are going back to Apple, are words that are used to market other products they normally wouldn't be associated with. So Apple for computers. And then typically we would caution people to register acronyms because most often than not, they're going to be used in a descriptive manner and stand for descriptive terms. And so usually, unless you're just going to be using the acronym kind of by itself, we're not going to recommend filing it, and they have potential issues if they're known or ordinarily accustomed to in a specific trade. So just a couple more slides here. And so this is kind of going to foundational agreements for IP protection within a company or early stage startup. And so agreements that you really should be considering early on are intellectual property assignments, non-disclosure agreements, employee and consulting agreements, and then establishing early service agreements. So IP assignment agreements, we do this with a lot of our startup companies. You'll see this in the founders documents. There'll be a founders IP assignment that basically will assign any intellectual property that was created by the founders of the company to the company at that point once we're doing the formation of that company. These IP assignment docs are going to also be critical if you have employees or if you are hiring a subcontractor to perform the work for you to ensure that they assign all right, title, and interest to the intellectual property that they may be creating for you. It's really critical that you want to have the company own the IP. So I already kind of talked about non-disclosure and confidentiality agreements. You can see these when you're doing initial discussions with potential subcontractors, with potential investors. You may still have confidentiality clauses within employment agreements. You'll want to ensure that you may have non-disclosure and non-use provisions in these type of agreements. So the non-use provision is kind of critical too, that, hey, you're not going to disclose what I told you, but you're also going to not use the information that I'm disclosing to you to try to create the product as well. So that is kind of employee and contractor agreements. So are they employees or are they contractors? There's tax implications, but there's also a focus on company control. And this distinction is somewhat critical and depends upon the state you're in too, because states have different laws when it comes to IP ownership. Some states have enumerated statutes of what is limited to be considered employee owned or company owned if they're an employee creating it. And so you'll want to have IP assignment language in there. You'll want to include confidentiality language, non-comp, non-solicitation. So you may want, non-comps are tricky, but non-solicitations could be very critical if one of your important IP assets is, let's say, a client list, right? And so not only can they not take your client list, but you also don't want them to be able to start soliciting your clients just from the memory of the clients that they've worked with. And so that could be a critical. And then early service agreements, you'll want to establish, especially if they're developing anything for you, and this is a lot for software companies and software development, is making sure the deliverables are well-defined, making sure that if they're creating the work for you, that you own the IP and that you define that in that agreement, kind of the service durations, when they're going to be developing it, when they're not, so you know what is going to be considered yours, what is not going to be considered yours. And you're also going to want to get warranties and waivers from your developers saying that they're not infringing third-party IP, and some kind of indemnification for the same reason. So I know I kind of flew through the last part a little bit quick. I know we're running out of time. We're kind of hitting on the end, but I'll kind of open it up for questions now. Sorry, I know that's a ton of information in a short period of time. I'm happy to answer any questions. Samantha will give you my contact then too if people are dropping off. So
yeah, well, we want to thank you, Tyler. As you can see, Tyler is a subject matter expert when it comes to intellectual property and copyrights and trademarks. And it's not those aren't easy subjects anyway, because every situation, there's a lot of different questions and answers, but Tyler is certainly one of those people that can provide some guidance. So I encourage you, if you still have any questions, we'll provide you with this contact info. As we had mentioned before, we'll provide you with a copy of this recording and the presentation that Tyler did. So I know there was a lot of information in there. So it'll be great to kind of have that as reference going forward. And we also want to thank CACI again for being this month's webinar sponsor. So every month we have a specific webinar sponsor, and CACI was the June one. So we appreciate CACI for doing that for us. If you want to see any of the other webinar series that we have going forward, or even just academy.com, you'll see a couple tabs for Purdue at Westgate webinar series. We also hosted Defense in Indiana webinar series, so as well as other events. We're starting to go back to some in-person events starting in July and August. So we'll be reaching out to some of you to see if there's any opportunity for you to attend, any interest. So thank you, Tyler, again. Thank you all for joining us. This was perfect timing, and I think we'll go off from there, and we hope everyone has a great rest of the week. Thank you.
Thank you, everyone. Hope you all have a great day.